All right, so as a few more people pop in, we'll get started. And just to make sure everybody's in the right spot, this is the view from the bench for the Cuyahoga County Domestic Relations Court. So I want to thank all of you for joining us today through the CMBA. And thank you to all the judges who are able to participate today. And a welcome to Jennifer Hemline, who's going to be our moderator today. Jennifer is a shareholder with Cabbage, Milo, and Durkin, and is also the chair of CMBA's Justice for All Committee. Thank you, Jennifer, for all that you do. For everyone who is here for CLE credit, please know that to receive that credit, you will need to be watching the Zoom on your computer as opposed to just calling in. And then you will also need to complete the survey that will be sent out to you at the end. Keep in mind that you can put forth some questions, and to submit those, you can use the Q&A function or the chat function at the bottom of your screen. And we will get those answered either during the presentation or at the end. So Jennifer, go ahead and take it away from here, please.
Thank you, Katie. Thank you, everyone, for coming. We are so very honored to have, currently we have 4 of our 5 domestic relations judges with us, and we hope that Judge Gold will also be able to join us at some point during the presentation. I'm sure most of you know who we have, but I'm just going to briefly go across my screen and introduce who we've got on our panel today that we're very excited to have with us. We have Judge Diane M. Palos. We have our administrative judge, Leslie Ann Celebrezzi. We have Judge Francine B. Goldberg, and last but certainly not least, we have Judge Tanya R. Jones. And again, hopefully we'll have Judge Gold joining us at some point during the presentation. As Katie mentioned, we're going to be monitoring the chat section, so if you do have questions as we're going through the presentation, please feel free to post your questions there, and we'll either address them at some point during the presentation or at the end. So we're going to get started with the first question that we have for the judges that came from some of our attorneys, which is, how are you handling pretrials, settlement conferences, support motions, dissolutions, and uncontested hearings these days now that we're not all appearing before you in the courtroom live and in person? I'm going to start, just because she's at the top of my screen, I'm going to start with Judge Palos.
So we've been doing as much as we can by Zoom and phone conference really since the pandemic started. It took a little while for everybody to get equipment and for everyone to have a laptop and to have Zoom capabilities, but everybody does now. So it's like it was before. You pick what is the best way to have the hearing or the conference, and then now, instead of necessarily in person, it could be by telephone or it could be by Zoom. I don't know. That's like a pretty generic answer. I mean, there was a lot in that question, so maybe we'd like to unbundle that a little bit and talk about it some more as we go through.
Sure, and specifically for Judge Celebrezzi, how is the court now handling dissolutions and uncontested hearings? Are those being handled in person, or are those being handled through Zoom?
We are actually doing both now. We were set for a soft opening the first week of June. Unfortunately, due to some circumstances, we had to move that back a week. So we have had some in-person hearings. I'm doing dissolutions and uncontesteds by Zoom and by telephone. I did have a in-person pretrial this week, and I also had an in-person pretrial that the parties wanted to get divorced that day, so I actually did it in my courtroom. So we're doing all of it. In order to have an in-person hearing, you have to be screened. Temperature check, you have to have a wristband. Today it's purple. And when you come in, if you're an attorney, you're allowed to go through the back door. You're sent up to the rotunda, and then we have someone sitting there that will ask you where you're going, and then they will direct you up to that courtroom when it's time for you to appear. So we're doing all of them. We're doing Zoom, we're doing telephone, and we're doing in person now.
Jennifer, I want to say something. First of all, I want to thank Judge Celebrezzi, who's been our administrative judge. We have the judges, we have our Friday morning at 10 o'clock coffee clutch to know in terms of to be apprised of the updates. But Judge Celebrezzi is along with Jim Zach and the administrative staff of our court have worked tirelessly. I mean, this is an unprecedented time. And every day it's changing. We didn't know when we were going to start, what was going on. Could we do Zoom conferences? There was a grant that we received. Judge Celebrezze, I don't know, we received it from the state or from the Supreme Court?
That was through the Supreme Court. They issued us a grant for all of our computer equipment in order to get up and running.
Right, so all of the things that are happening now, Jennifer, really have been a lot of sweat equity that has been behind the scenes. And to make this a courthouse where not only, you know, the judges and the magistrates and court employees feel safe, but that the public over a certain process in different phases feel safe. So kudos to Judge Celebrezze and the staff, because this is really, every day is changing and you have to pivot, and you know, not only want to be reactive, but you want to be proactive.
Thank you. And Judge Jones, how about in your courtroom? How are you handling your various hearings and trials?
Well, most of our, it's pretty much the same way that Judge Celebrezze and Judge Palos are. We're all kind of doing the same thing, and that is, you know, through telephonically or Zoom. The plan is, starting maybe sometime in early July, is to bring those cases. I've been scheduling cases that are a little bit more complex to come actually in for pretrials on my days for in-person hearings, which are Monday and Wednesday. It's Judge Celebrezze and I will have those days for our in-person hearings, and the other judges have Tuesday and Thursdays for their days, and then, you know, Fridays are open. But the cases that are a bit more complex and aren't making the kind of progress that my magistrates and I feel that they should be, we're scheduling those actually in the courthouse.
Okay, great. And Judge Celebrezze, just to piggyback on what you started to talk about earlier in terms of getting into the courthouse and bringing in witnesses if we are having hearings, how is that working these days?
Well, each courtroom has been marked with capacity as to how many people can be in here. So if you exceed that capacity, and as I'm looking at my courtroom, it looks like 1, 2, 3, 4, 5, 6, 7, 8, about 9 to 10 people can actually be in the courtroom. So if you exceed that amount, the witnesses will have to stay in their vehicle, and then we'll have to call them, or they can also stay in the rotunda since there's seating there. So they can stay there until it's there, which is probably easier than staying in your vehicle. So you could stay in the rotunda, and then when we need you, we call downstairs and we can have you brought up.
And when attorneys want to or going to come into the building, is there a list that they have to be on in order to get in the building?
There is not a list. What we have is what used to be called a red coat. I guess years ago they had red coats in the Justice Center, so now that's what we have here too. So there's someone at a desk, at a domestic relations desk. There's also a probate desk and Court of Appeals. And when you check in, they'll ask for your name. They have a computer with the CMS system on it, so they'll be able to see who's on that and where you're going. So if you come in and you say, well, I'm supposed to see Judge Jones, and they look and say, well, there's nothing on Judge Jones's docket today, the courtroom's called, and then they question as to why you're here. So if you actually don't have a case set, that's going to result in a problem because we don't know why you're here. So there's no actual list, but since they have a docket in front of them, that constitutes the list as to who can get in. Now, attorneys have called and asked to drop things off. So sometimes either Roberta or Georgia will go meet them at their vehicle or at the back door to bring things in. So I don't know, that's what we're doing in my courtroom, that will allow you to drop things off if you need something that you want me to see right away. So I would suggest just call whatever judge or magistrate you want to see and see if they'll, accept a pleading or something at the door.
And a lot of people are asking questions about whether and when we should have clients present with us, either on telephone hearings or on Zoom hearings, and that information isn't necessarily always received in the court notices. Is the court going to be advising the attorneys about when we should have clients present, or is that something that the judges may or may not update on your bio pages on the website?
Our notices.
Oh, go ahead, Judge Bailey.
Our notices do say attorney conference or pretrial. So if it's an attorney conference, we don't expect the parties. If it says pretrial, we're going to expect the parties. The only glitches that we're finding is sometimes the parties are in the room with the attorney. There's no opportunity for an off, private conversation just with the attorneys if they're all there. So, people may want to make sure that they let the court know that the client's sitting next to them. So that something, so everybody's behaving appropriately, because sometimes things are said when the clients aren't in the room that shouldn't be said. They really are on the notices. And if you have an issue, then you need to call the particular courtroom, but we're all putting them on the notices.
Jennifer, I know in my courtroom, and I do want to thank Nancy, my bailiff, and Linda, these things have been easy for me because of all the front end work, with regard to my staff and as well as the help center and Anjanette Whitman. I love Zoom, I have to tell you, and I'm a dinosaur when it comes to technology, and I really love the beauty of it. And I actually think litigants and families like it. The other day, it was an uncontested case, and a gentleman was in Walmart, and I said, would you like to go into your automobile, or maybe, a little bit of privacy? And I don't know, he looked like he was near the light bulb section, I don't know, blue light special or something. And I actually think litigants really like it. I mean, listen, you've got to figure, and again, but there's a lot more work on the front end with the help center, especially if someone is a self-represented litigant. There's a lot more work for them on the front end. We get it and it's done. Or there's some issues that we have to work through. But I think generally speaking, and my staff has a lot more contact with a lot of these individuals, but they don't have to pay for parking. You don't have to take a day off of work. I think more people and even attorneys are really on time when we're in a Zoom, I found at least in a Zoom pretrial conference. Everyone's very prepared. Things are, upfront. We know what to expect. And we try to work with people. Sometimes, listen, we can't hear someone, we can't see someone, we'll wait, we'll figure it out. I mean, this is, at least for me, but it's a learning curve for everyone. And we want to be responsive to those needs in terms of with this pandemic that's over everyone's head. So.
And we had a question coming in about contested Zoom hearings. Is the court going to be putting out trial orders detailing the protocol for Zoom hearings? And do any of the judges have any preference for how you want documentary evidence to be presented to the court, either in advance or at the time of the contested hearing? Judge Jones, we can start with you.
Okay, there we go. So I guess I'll start by saying my preference is not to have contested hearings by Zoom. I just think that it makes it a bit more difficult for me as a decision maker. However, I understand that, there may be a need to have some type of emergency hearing. So I think that Judge Palos actually drafted a really thorough order that we're all going to be using if we're having a Zoom hearing, that speaks to, providing copies of exhibits and things like that to the court and to the other parties in advance. So I don't know, Judge Palos, if you want to talk about that.
Sure. So I have actually had a couple of hearings already, using Zoom, and I did create a supplemental trial order if it's going to go to trial by Zoom, and I wait to put it on until kind of the last minute, just because something may settle, or I already have a standard pretrial order, and since this may or may not be the new norm, it's no point in integrating the Zoom part into the old order. So I think it's pretty simple. Simpler than people think to do this. It's not perfect, but neither is a trial in person. The Zoom provides for the waiting rooms, so you don't let people in. Witnesses can be given the link, or they can be given the link, in advance or at the last minute. There's ability to share documents on Zoom. So, I mean, you can pull a document up and, say, like, everybody can be looking at the tax return, and the attorney can refer to, line 14 or line 16, and everybody can be looking at it at the same time. As far as getting the documents generically, the same issue as when we have trials. I mean, I think it would be good if we, had either a trial notebook, a hard copy, or a jump drive, CD, something. People can do document drop. There's a lot of different technological ways we can get the documents. But the main problem is not getting the documents. The main problem is understanding the documents. And this is whether they're in person or not, because people tend to put them all in one PDF. If there's, even when I'm given the documents in advance of the trial, they're not necessarily indexed. And so if you're going to be having a trial and you're doing this by Zoom, it's particularly time consuming, for us to be trying to scroll through our computer screen to find, a page that's probably not even numbered because it's 14 different documents. So the key is, and this is for all of our trials, and I think this is going to make us all better, we need an index, we need the right document, we need the minimum of documents, we need a summary document. We don't need, 20,000 pages, boxes and boxes of stuff. Almost never is that relevant. Almost never do we need that. So, I think we all just need to be a little bit better about picking what's the right document and then getting it to us. So what my trial order says is that at least 48 hours before the trial, I want a trial notebook, 2 trial notebooks, one for myself and one for the court reporter. So the court reporter has the documents to mark. I want it indexed, and it can be sent electronically. Again, the more documents there are, the, maybe the easier it is for us to have it in hard copy, and the harder that is for the attorneys. But that makes, I think, more sense, and it makes sense for the court reporter too. So I've done these, the court reporters in her dining room, I'm wherever, the people are wherever, and I want to sort of piggyback on what Judge Goldberg said. I really think the litigants themselves are much more comfortable, at least on the uncontested cases, coming in on Zoom. They're more relaxed, they're not fighting with each other, they're just calm, they're kind, I know that they're more attentive, because I've always asked people, do you have any questions? And no one's virtually ever asked a question in the courtroom, and on Zoom, they always ask questions. So I think it's kind of a nice thing. I mean, again, not for everything, not forever, hopefully, but I think we can get through this and keep everybody safe doing it. And maybe in the future, keep doing some of the uncontested things by Zoom.
Judge Palos, the only thing is, when I had one uncontested case, I thought the plaintiff was coming out of the shower, and I just kind of told her if she could just put some clothing on, like our regular rules in court, to dress appropriately for, even though you could be a little bit more casual, to dress more appropriately in court. But I really think, and maybe we would do a survey, I really think families and litigants, to not have to take off that day of work and that vacation, they're really very grateful. But again, and I can't reiterate it enough, all of our staff members are working much harder to make this work for families and for the judges, because there's a lot of front-end information and a lot of emailing going back and forth, as well as, with this, any kind of trial order. It's the preparation is much more labor intensive to make sure that case goes forward.
Yeah. Can I just give an example? So, in the past, if something wasn't signed, or, if something needed to be interlineated, the people are all there, we'd get it signed. The staff would just hand it to them, they would sign it. Now they have to email them, call them, email it again, send them the document, call them again. So getting every single form signed is a heroic effort, and our staffs have been doing that since the beginning, and really, really working hard, and it's very stressful for them.
Yes, I would have to say that I know I've been on some CMBA bench bar committees and working with Judge Calabrese and just other various members of the court. Everybody has done a fabulous job of trying to transition all of our cases and all of this work, and we can't thank the staff enough at the court for doing that for you guys and for us. We had a question come in on chat. It says, are you considering making that order a local rule so there's consistency to all contested matters throughout the building? Nobody wants to take that.
Yeah, guess I'll answer. At this stage, I would say probably not. I mean, making a local rule is time consuming. So since we're all following Judge Palos's order, which is great. I would say just look for that now. We'll just use Judge Pistol's order so it's consistent. But we have to always remember that we're all autonomous here. So some things are changed with each judge. But I don't foresee that in the future right now, making a local rule. I'm sure we can revisit that. And the judges will have to have a discussion offline about that. So it's the best answer that I think I could give you right now.
I have to say also, even in using it, and I've used it, I put it on 4 or 5 times at least now, it's a different order. The heart of it is the same order about the Zoom information and the document information, but if it's a self-represented defendant versus a self-represented plaintiff versus a guardian ad litem, if it's pre-decree, post-decree, is it a motion or is it the actual trial? But if the other information is different, it's tailor-made for every single case. So it's, I haven't loaded it in our case management system even to use just because of that, because it morphs every time.
Okay, thank you. We also had another question come in asking, how are you handling subpoena compliance for witnesses for Zoom hearings, such as their inability or unwillingness to participate by Zoom, and in-person appearances such as refusal to attend? I don't know if this issue has even come up for the court yet. Well, seeing as how we have no response, I'm going to guess that you guys haven't had to address that issue.
No, it hasn't come up yet. I haven't done a Zoom trial yet. I did a motion to show cause via Zoom. So I haven't had the issue of subpoenas yet.
And one of the questions that we also had is, how will the court handle a situation where one attorney wants to appear in person for a trial and one attorney, whether for health or other reasons, wants to appear by Zoom for a trial?
I think in that situation, we'll try to, I mean, obviously they both need to, at some point we need to be on the same page. So either it's going to be by Zoom or in person. And if I came across that in my courtroom, then I would just require that we come into the courtroom and have the trial in the courtroom, or continue it if we can reach an agreement regarding that, if it's a true health emergency or health compromising issue. But otherwise, I would expect that then we would come to the court and proceed as we normally would.
I haven't had that issue yet. I do have a case where it's been discussed. So we're kind of trying to figure out the majority of the attorneys and clients will actually be present in the courtroom. So if we have an attorney that one wants to appear via Zoom, I don't know how we're going to work that as of yet. If I have to get a video screen in here, because it will be for me, and I think for the other attorneys, it's going to be very difficult to have someone present via Zoom and trying to question while they're physically in the courthouse. So I agree with Judge Jones. It's kind of like either we have to continue it or we have to somehow figure out a way that maybe you could be in a different courtroom in here so that you're not going back and forth. So I guess for me, it's like, stay tuned. I'll see what happens with this case when it finally goes forward.
Jennifer, I think, again, these situations are fluid, and I think as judges, we are speaking much more with the attorneys and having attorney telephone conferences and Zoom pre-trial conferences. And so these issues are fluid, and clearly we're going to be responsive to the needs of a health situation. I know my magistrate, Canonical, had a trial that started last week. It was Monday and Tuesday, and then they came back Friday, and they ended up settling it. And I think there were about 6 people in the courtroom. But it's configured in a way where I know Judge Celebrezzi and Jim Zach kind of, we worked through, the logistics of how this courtroom would look and people being outside. And there aren't really that many people that are here, during the day. So there's enough space. I think, is it about 35% capacity, Judge Celebrezzi, something like that?
Yeah, we're at 30 to 35% capacity
Right
in the building.
So clearly with that in mind, we're going to try to work with people, whether it's a witness or an attorney or an expert witness or whatever there is, to be very cognizant of everyone's health situation.
Thank you, Judge. Another question that we've had is attorneys would like to know, are they going to have time to conduct settlement discussions before starting a trial, if that trial is either in person or by Zoom?
Well, I can only speak to what's in the current order that was journalized in May. We prefer that no one is congregating in the hallways. We've removed the majority of our benches and areas to sit in the hallways. So that's what we're trying to avoid, is the congregation in the hallways. Now, I guess for me, if you came into my courtroom and we were set for trial and you said, can we have an hour? If you're staying in my courtroom, then I would leave and let you have that time to try and settle. Every day, every time a courtroom's used, it has to be sanitized. So that's why we're also limited to, Judge Jones and myself are here on Monday and Wednesday so that the cleaning can be done, and they only have to clean 2 courtrooms. And then the other 3 courtrooms, they know Tuesday and Thursday, they have to be sanitized. So I would advise, if you think you're going to want to settle and you don't want to come into court, I do know that a case called and talked to Georgia, and she said, just go to your offices and settle and let us know. Like, we don't want to bring you in here and have you in the building for no reason. So if you prefer to settle, then just, and there's Judge Gold, just do, Judge Gold. So that's how I'm handling, but we're looking at it from the standpoint of, we're, in terms of the health and safety of the public and, the staff here, we don't want a bunch of people congregating in the hallways, and that leads to more problems. So I don't know if that helps or not, but that's just my statement on that.
What I've done when I've had the Zoom motion hearings and trials set is I've had the attorneys come online with me on a separate Zoom number invitation in advance. So like at 9 o'clock or 10 o'clock, and then have the trial set at like 11 o'clock. And we've tried to, last minute settlement. They often have their clients in the office at that time. And it's been pretty effective. We've either settled everything or settled part of it so that we had a very abbreviated trial. So, I think it can work. It just can work.
And I just want to note that we do have Judge Rosemary Gradina Gold. She just joined us, looks like from the beach. So we're all very jealous.
And that's good old Lake Erie.
Oh, okay, great.
Sorry for the delay. I had a number of issues going on here, but that's all right.
Well, we appreciate you joining us. And now we have all 5 of our judges here. So we're very grateful that you could all make it here to answer some of the questions that our attorneys have been having. I had a question that came in for Judge Jones. It said, would you consider an age a health issue significant enough for an attorney not to come to court?
Yes, I would. I would consider that. I think that, like we said, this is very fluid. We don't want to compromise anyone's health. We want to be, aware of that. Also, concerns for our staff as well. So I think in that particular situation, if opposing counsel was adamant about having the trial heard in the court, I would just continue it. I think I also want to point out that we're not over scheduling at this time either. So even if you're coming into the court for an in-person pretrial, there's an hour in between or more in between each of the cases. So if you're in our courtrooms and you're set for trial, then you're likely to be the only case set for me on that particular day. So, you're going to be able to use the courtroom without having concern about, other cases coming in and you're having to share the courtroom. So there would be time for settlement and negotiation to try to resolve the case as well.
One thing I do want to say is that there's no prohibition against us calling our case in any way that we want to call it. So if we say it's a Zoom hearing, it's a Zoom hearing. The only reason we were asking people about the dissolutions was that the governor's stay affected the dissolutions because they're statutory. Every other thing is not statutory, and we don't have to ask permission. So for me, if I have one person who's feels compromised by their health and can't come into the courtroom, then everybody's out of the courtroom. I think it's a little bit awkward to have people in and out, and we don't really have the technology for that. I mean, if we had to do it and everyone agreed to it, then that might make some sense. But I think we have to go to like the, kind of like the least common denominator. Whoever is unable to come in, then that's where we go. And if everybody's able to come in and we feel it needs to come in, then they can come in. But I think we're being really careful about letting people in, and also, we're still doing the uncontesteds and trying to get through everything that we had. And, where some of the trials aren't going forward just because of that as well.
Jennifer, I also want to say I had 2 attorneys this week that wanted to come in physically, and we tried to talk them out of that and to do Zoom. I don't know if it was because of, being intimidated by the technology. I don't know, but they wanted to come in, and that meant, 2 other people coming in each of those uncontested cases. So, again, it is fluid. And the other thing is, with this pandemic as a backdrop, let's be honest. I mean, some of these more complex cases are a little bit more difficult to settle. You have pensions that have been decimated. You have people that are out of work collecting unemployment. So when we talk about these cases, the judges and staff and magistrates being responsive, we have to balance that fine line between health issues, between a tremendous economic downturn and issues, that have come up with regard to parenting and relocation and medical personnel and COVID. But I think that we have really tried to be very responsive to especially the health needs of the attorneys and the families that come before us.
Thank you, Judge. Another question that attorneys are asking is, when hearings are being conducted by Zoom, when would hearings be recorded using Zoom, and would those recordings be available to attorneys for purposes of objections or future motions?
When I do a Zoom, do you want to speak, Judge Gold? Go ahead.
I was going to say, I set up my Zoom hearings, especially the dissolutions, to automatically record. And then at the conclusion of the hearing, the recording is downloaded to something or other on my laptop. I'm not sure what file. I know it's in there. So we are recording them. If we do anything in our courtroom, if it's by Zoom, we can also use the computers on our desk, because we have the recording system there. So, and those are all available to court reporters to transcribe. So that shouldn't be a problem.
What I usually do is I'll digitally record it in my courtroom if I'm in my courtroom. I've also had a court reporter, if it's a motion hearing, and they can appear via Zoom, or I actually had the court reporter, she wanted to come in, so she was actually in the courtroom when I did it. So I'm recording them usually on my digital recorder, because if you record on Zoom, it goes up to the cloud, so you can find it that way too.
Thank you. We had a question come in, I think in response to something that Judge Gold mentioned. So an attorney asked, how do you tend to view child support modifications given people having lost jobs altogether or a decrease in their income since late March to the present?
That's addressed to me.
Any of the judges.
I have to take this to the court. The court's calling, hold
on. Don't we all have to do that? Hang on, the court's calling.
So with, motions to modify child support, I'm going to be honest, I always send those down to one of our very capable support magistrates. So since we don't have one here, they'd be able to answer it, but we are looking at them. I mean, I've gotten a lot of modifications of child support. I also have received a lot of modifications on spousal support. So normally what I do is I send them down to a support magistrate, and then we talk about what ruling they're going to make. So that's what I've been doing, is sending them to a support magistrate for hearing.
Thank you, Judge. Along those lines, one of the attorneys asked, how are courts addressing issues such as business valuations in these uncertain times?
I have not had that come up yet in any of my cases. What I would assume is if you had a business that was valued prior to COVID-19, and depending upon what that business was, my guess is you're going to have to get another business valuation done if it was something that was affected by this pandemic. And that's all I can, like I just said, I haven't had anyone bring up that issue yet regarding a business valuation. Has anyone else had that happen?
I had one where the business actually has gotten better because it's a cleaning business. So interesting. But again, any of these things with numbers, with the tax returns, with, you know, like that last year's tax return number is going to be completely different than somebody's, you know, income as of June of this year, because maybe they were unemployed or their salary has been decreased. We have to look at that, and we have to think about whether this is permanent or temporary, and what does it mean. And if it, you know, a lot of people's pay have been cut like 10 or 15 or 20%, I think we have to use that number. But obviously people can modify support when this is over. And the values of the business too, we don't know. I mean, some of this stuff, it's terrible. The things with the pensions, you know, if we think about somebody who settled in January and was supposed to pay a amount certain out of an account, you know, by the time they get the paperwork done, the amount certain might be the entire account or more than the account. So these are terrible times, and I think we're all going to be flexible on this. And, you know, I know everybody wants rules, and they want local rules, and they want order, but things change not just weekly, they change daily and hourly sometimes. And like we said at the beginning, we're meeting every week, we're talking all the time, we're keeping in communication, we're doing the best we can, but it's just an awful hard situation for everybody. And it's terrible for our litigants who are, you know, potentially out of work, and we don't know if they're going to go back to work. We don't know how much their salary is going to be. You know, luckily all this stuff is supported, at least is modifiable. The business valuation, I think, is a much harder issue because it's going to be a finite number.
Let me just interject that I think everybody has to look at this outside of the legal system. And the last resort should be coming back to the court to litigate how much somebody should pay who's been laid off due to the pandemic. These are practical matters that we've never faced before. And both parties and their counsel need to cooperate and try to come up with a resolution that works for the family on a short-term basis without going through a hearing and asking the court to make a decision for them. It seems to me that it's got to be more personal for these litigants, and the court should be the last resort.
Thank you, judges. We had another question come in. If an attorney is on another Zoom hearing with another court and they're scheduled to be on a Zoom hearing with one of you folks, how would they notify the court that they are unable to appear on time?
That actually happened for me this week. You know, I would just request that as a courtesy, if you know that you have a hearing scheduled at 11 o'clock and you're scheduled with me at 11:30, just notify my courtroom staff that you are, maybe running late. And typically what I will do is go ahead and start the, sign in, and then put the other person in the waiting room until both attorneys are there. So just make that just as you would if you're running late. If we were having hearings in person, make that courtesy call to the courtroom to let them know.
Yeah, I agree with what Judge Jones said. Just call us. I mean, and I know that when my Zoom hearings are set, there's the notice that goes out said, be prepared like half hour before and a half hour after, because there are times when I'm still doing a hearing or in a meeting and I can't get on at 10 o'clock to have your Zoom. So you have to be patient and always just call, because someone's going to answer the phone and say, yes, she's coming, or, if the attorney's running late, same if you came in person. Well, I mean, I'll wait for you. It doesn't just call us and let us know so that we know you're going to be late.
Jennifer, I wanted to interject also. I don't want to speak for my colleagues, but in the beginning of the pandemic, at least my courtroom received a lot of emergency motions as it related to parenting time and COVID-19. And, you know, again, and we've gotten less of that now. I think, you know, I don't know now with numbers spiking and everything, but, and I know that my colleagues and I had spoken about this, as well as looking at, you know, parenting time, but that COVID-19 is not an automatic suspension of parenting time, nor does it result immediately, you know, in an urgent hearing. But we were getting a lot of these motions with regard to, or at least I was, with regard to, you know, individuals in the medical field. And trying to navigate that. And again, I think that, you know, these are difficult times, these are unprecedented times, and it's about, you know, having those attorney telephone conferences or those Zoom pretrial hearings to trying to figure out and vet what some of these issues are, and it's challenging. You know, if you have a doctor or a nurse that's in the medical field and one parent doesn't want the children to be with that parent. But I was getting a lot of those motions on the front end of this pandemic. I don't know if my colleagues want to also kind of interject in terms of what they were getting with that.
I think we were all getting those motions. I think, and that's why we did, I think we have an administrative order that came out in the beginning with that. So, and I want to thank the other judges because they would get an email from me with this order that was written at midnight that was misspelled, and everyone would collectively fix it. So it was a group effort in every order that came out, and every problem, any issue, we would always be discussing it. So that's, to me, that was the greatest part of this, is how we all work together. But we did have a lot of those emergency motions. That's why we crafted the order saying, this doesn't stop, you know, it's not summer vacation, it's not spring vacation, school's not over. This pandemic you don't get to delete one parent because of it. So I think it's calmed down, at least now. I'm not getting as many motions. I don't know if everyone else is still getting them, but I'm not getting as many regarding the parenting issues. I think those were straightened out with a few orders.
Judge Jones or Judge Palos or Judge Gold, have you experienced any of those similar issues with regards to parenting?
I think that initially, you know, as the other two judges said, we were all kind of getting a lot of emergency motions to suspend parenting time because of the pandemic. Now I'm just back to the old mean, nasty pettiness regarding parenting time. So things are kind of getting back to normal regarding that.
Judge Palos or Judge Gold?
Yeah, I think I had one motion this week about my wife's not letting me, or my ex-wife's not letting me see the children because of the pandemic, but I really haven't had one for quite some time. Again, you know how it is. The people that are less interested in sharing the children, this has been a great excuse for that. And there have been some valid concerns, but if it was an intact family, they would have figured it out, like, you know, mom or dad comes home from the hospital and changes in the garage, takes a shower, and then talks to the kids. And it can be the same thing with possession time. So I think, you know, I'm not seeing it that much right now.
I didn't have that many motions. Certainly there were some, and then after we issued, Judge Celebrezzi issued that administrative order, it kind of quieted things down. But whenever I had a motion, I just would try to get the attorneys on the phone, or have a magistrate work on getting the parties on the phone to try to work it out. You know, I'm finding, and I'm a firm believer, that people can really solve a lot of the problems when they have to. I mean, we were not available. The court itself was not available for people to end their disputes, as Judge Jones says, their petty little bickerings. And so guess what? They had it figured out themselves. What a great thing. I hope that carries forward once this passes. But, you know, it just, when you don't have the court there to fall back on, you have to take your own measures and really communicate and try to get things resolved.
I'll tell you, I do have a concern. You know, I think our pro se litigants is about 65% now. And with the pandemic and the economic uncertainties, you know, I hope that that number does not rise. I think the cases are challenging enough with really good lawyers. But, you know, when economic times are tough, I don't know if families are going to be able to be in the position to retain lawyers. So I don't know, that number might go up. I don't know.
The other thing I'd like to say is we always have, you know, all of us, the court, the attorneys, we're all jaded because we see some of the worst behaviors, but I've had an awful lot of cases where the people have been like sheltering together or really sharing the kids or coming up with other ways to you know, be with the kids that's safe. So, I mean, there's been an awful lot of good behavior too, and we focus on the bad.
Thank you, judges. We have some questions coming in from attorneys. One specifically says, with respect to emergency motions, how quickly are they being scheduled in each of your courtrooms? Because clients are asking to know what to expect.
I can answer, as far as I'm concerned, I get on the phone. I just get on the phone and talk to the attorneys and find out immediately what is the issue, as opposed to sending out an order and saying, okay, we're going to try to do this by Zoom. Communication to me is key. We have to, I need to find out what exactly is the issue. And it's like half the time I find out that the attorneys have already worked something out, that they've communicated, the parties have or whatever, and you know, the issue is resolved. As far as emergency motions, again, it depends on what the situation is. And it starts with a phone call, and if it has to go to a hearing, we'll do the best we can.
I agree with Judge Gold. I get people on the phone right away. But you have to understand, just because you call something an emergency doesn't make it an emergency. And our practice is not to sign those things ex parte. That all you do is end up with a worse mess, because our local rule does say that if you do some kind of ex parte order, you have to have a hearing to undo it. So nobody wants to get in that position. So we're really careful not to sign those things. And sometimes if it's really an emergency, then maybe it's something for Children's Services or a DV and not something for us.
You know, if it's a true emergency and I sign an emergency order, which I will do, I have the hearing in 3 days. I have signed emergency orders and then called attorneys and said, your hearing, when do you want to have it? It's 3 days from now. And then they declined to have the hearing in 3 days. So if I'm signing an emergency order, you better be prepared for 3 days. But some of the, like Judge Palos and Judge Gold said, some of the emergency, it's not a true emergency. So if it's not, I probably won't have a hearing on it. You know, I'll either rule on it on paper and deny it, or we'll call you and ask you what the real problem is. You know, if it's a DV situation, don't file an emergency, or, you know, file domestic violence. On the other side, don't file an emergency motion and it's denied, and then go file a DV. So there's a balance there too, of whether or not it's a true emergency.
And like the other judges, I've been getting the attorneys on the phone and trying to see if we can, you know, talk through things and reach an agreement. If not, I'll usually set it within 5 days.
I get everybody on the phone right away, and then we set it right away. So just because there's a pandemic, you know, we've got to filter through whether, if in fact, as my colleagues have said, is it really an emergency?
We've also got some questions coming in, Your Honors, about spousal support. So along the lines of child support, attorneys are asking about, you know, what are you seeing with spousal support, and what are your thoughts on spousal support modifications in light of the pandemic?
Well, I think it's very difficult to say that we have a blanket policy regarding that. Of course, everything's on a case-by-case basis. However, if there is a legitimate decrease in income because of the pandemic, then certainly we have to take that into consideration. But, you know, like, and I have a couple of cases where, you know, those motions were filed for the temporary orders, and basically, you know, it comes to find out the person has continued to receive their regular income. That, you know, their argument was that, well, they incurred additional expenses for food and, you know, things of that nature because they were sheltering in place. well, that's not a decrease in your income. I mean, you know, so that's not really a reason to get your spousal support decreased. I think that, you know, each case is individually, and so we have to consider it at that time. So I don't have a blanket policy regarding spousal support.
Again, spousal support may not be modifiable if we're talking about post-decree. So it's one of those reasons why, you know, when you're doing your divorce settlement, you may want to consider, most people don't, they like to tie that number in, but this could be a reason that we should have made it modifiable, and we can't modify it if it's not modifiable.
Well, it could be coming in on a show cause too. I've seen more of those. And, you know, this is a pandemic that's affecting everybody. It's not just affected. I look at them, the cases, and I say, well, if the husband is the payor, the obligor, and he has lost his job, or he's his income has drastically gone down, that's the wife's issue too. They've got to share that burden. And again, it's communicating, and, you know, can you put your heads together, put your money together and say, what bills do we have to pay so we don't lose our home or have our car repossessed? They should be doing that together. But I sound like a broken record, aren't I?
Thank you, judges. We also had a question wanting to know, back to safety protocols at the courthouse. Are masks required when we're entering the building?
Yes, masks are required, and that's pursuant to the latest order. There was also an order cut by Judge Sheehan, who's the presiding judge of the Common Pleas Court. So masks are to be worn in every county building upon entrance.
Also, attorneys are asking questions about if we are having in-person hearings, are the attorneys going to be given instructions on how to, you know, approach a witness or things like that, just the logistics when we're in the courtroom to practice safe social distancing?
Yes, they will be. And we've actually changed the layout of the courtrooms. And so I think it's pretty, I'm not going to say pretty obvious, but definitely, like, the tables have been changed around, the seating has been changed around, and so, and there's also markings in the courtroom for social distancing.
Jennifer, it looks like Safety Town in my courtroom. I mean, and we've got tables and X's, and there's like plexiglass, and I mean, I think that the county in general has really tried to make the courthouse, especially if it's only 30% occupied, as safe as possible for people that have to come in.
Along those same lines, if attorneys are having a trial in person in the court and they meet, how closely, I mean, typically we'd be sitting at a table right next to our client and talking to them. Are we going to have the opportunity to take breaks to maybe go outside of the courtroom and speak with our clients in private? How will that work? And as well as on Zoom hearings, if we need to speak with our client in private and we're not in the same room together.
Yeah, if you're in the courtroom and you have to talk to your client, you're going to have to probably go outside unless you're comfortable taking your mask off and whispering in your client's ear. I mean, everything is marked. There's a 6-foot difference between the chairs. So it's also the attorney and the party's comfort level. If you are not comfortable taking a mask off and speaking to your client, then you'll have to go out in the hallway and speak to your client out there. Same with the Zoom hearing. I don't think you're going to be wearing a mask unless you're. So, and you can ask on a Zoom hearing, can we stop so I can speak to my client? But it's the comfort level for an in-person hearing as to whether or not you want to take your mask off and speak to your client. That's up to the attorney and their client.
What you'll find is that the client is sitting off in a corner and you're sitting at the table. So you can't be talking to each other or whispering to each other, which is why it actually kind of makes almost more sense to do the Zoom hearing, because in the Zoom hearing, you can set up a meeting room. The host, which is us, can set up the meeting room and can send you and your client into the meeting room to talk, and no one else can hear or see what's going on. And then you can, you know, hit a button and come back in. And then you and your client aren't at risk of whispering in each other's ears. in the corner of the courtroom or out in the hall.
We had a question come in on chat. It said, will attorneys need to keep their masks on when participating in an actual trial, or will they be permitted to take them off? I mean, you sort of answered that, Judge Calabresi, but I guess throughout the entire trial process, when we're in the courtroom and questioning witnesses and things like that, will the attorneys be required to keep masks on?
I'm going to say my permit's a personal preference. I know I'm far enough away from everyone in the courtroom. I will probably not sit up here and wear a mask. It's hard to speak and it's hard to hear. When I had 2 pro se litigants in there the other day, we were all wearing masks and they asked if I could take mine off because they couldn't understand me. And I said, as long as you're comfortable, I'm fine. I'll take it down so you can hear me. So I think it comes down to your personal preference as to if you're more comfortable speaking to the witness and having your mask on or, having your mask off. I know that other courts will say wear a face shield instead. So if you're more comfortable wearing a face shield, we'll let you do that too. That's probably easier to speak to your witness that way.
The other thing is that in the magistrates' rooms, they also are marked off, and some of them can have 3 people and some of them can have 5 people. Some of them can't have anybody, depends on the size of the room. But in those rooms, I think you can't take your mask off. I mean, technically, the county says everybody in our buildings has to have a mask on at all times, unless if they're in their own office by themselves. So I think in our courtrooms, you might be able to go without a mask if you're the lawyer and you're far away from everybody. But I think with the magistrates, you're going to have your mask on.
We did have another question come in. Someone wants to know, has anyone who works in the courthouse been confirmed to have COVID-19?
Not in the old courthouse, no. None of our staff, none of the domestic relations staff has tested positive for COVID-19. None of probate, none of Court of Appeals. So as of today, no.
Well, oh, you know what? I think we might have one more question. We have one more question that came in. If the Zoom hearing is being recorded, are the meeting rooms also recorded?
I'm going to say
I haven't done that yet.
Yeah. Go ahead, Judge Go.
I haven't done that yet, but all you have to do is stop the record button. I mean, there's a record button on the Zoom. So if you don't want it recorded, then you just click don't record.
And I'm going to say, I don't think so. But when I put people in meeting rooms, because nothing is transpiring, I always just hit stop recording. So just like I would if I was on the bench to pause the record.
I just want to bring up one more thing. We talked about transcripts before, but our court reporters are still available to type the transcripts from the Zoom hearings, and we all have them on the cloud recording. So anything that's been done by Zoom is if we didn't have the court reporter present, they could make a transcript for anybody who wants it.
Would the procedure be the same for requesting a transcript of a Zoom hearing?
Yes.
Okay. We have one more question that came in. Will courts have masks available for litigants?
We do have masks. Should you not have one, I mean, we prefer that you bring your own because we can go through quickly, but we do have some available if you do not have one. But we would prefer you wear your own face covering.
And one more question that came in. Will you authorize counsel to record proceedings such as hearings, pretrials, etc.?
Are we talking about on their own or in lieu of some other formal recording? We don't know.
I think
if we're recording it on Zoom or there's a court reporter or we're recording it digitally, that should be sufficient. I would have an issue with an attorney bringing in a tape recorder and putting his phone on or whatever and recording something. I think we still have to comply with what would be an official transcript of something. Maybe I'm not understanding the question.
Yeah, I don't think I got the whole thing. So the question was, will you authorize counsel to record proceedings using Zoom, which requires the authorization of the host? So it sounds like maybe in a situation where the court wouldn't otherwise record it, would an attorney be allowed to record the hearing?
I would have to say for me, it would be a no. If I'm not recording it, I would prefer that no one else is recording it. Such as in a pretrial, I would have to say no in this corner.
I would say no also. We have mechanisms in place, just like if this was a live pretrial or in courtroom, I have everyone shut off their phone, so I see there would be no difference. I would not allow attorneys or individuals to record.
Same here. I wouldn't allow recording either.
I'll go with that.
Right, I agree.
No for
And
me.
I think there's a way that the host can allow or disallow the other participants to record. So I think in our settings, it's already set that way.
Well, thank you, Your Honors. I don't see any other questions. We do have thanks from our attendees for the very informative session, and we appreciate all of you taking the time to get on here and give us all this information and share this with us. Katie, did I miss any other questions that you saw?
No, I did not. Everything came through. So thank you to all of you for your responsiveness to all of these questions. Very helpful for all the participants. We're up to 60. So thank you for all of your time today. Jennifer, thank you for leading this and moderating it, finding all those questions, and all the attorneys participating. For anybody who is participating, please just remember to watch your email for the survey that'll come through, and that will go ahead and confirm your CLE credit for the day. And thank you to Jennifer specifically, as well as our co-chairs of the family law section, who have done a great job in some CLEs. We still have a Zoom 101 if somebody still has some questions about how does it work and everything. Brendan Donovan from the CMBA did a great Zoom 101 with Kylie Weinpertner, and that you can find on the YouTube channel for CMBA. So that can be helpful. So thank you everyone for your time. Have a great weekend.
Thank you.
Thank you so much.